My name is Tom King, and I'm the founder of Toolkit.law. We are expected to be joined by two attorneys who I greatly value. Attorney Keith Gross in the United States and the state of Texas, practices near the Houston, Galveston jurisdictions, is with us today and has mediated with me many times. And we're going to get also have Ronique Bastine join us. She had a conflict, but I want to give Ronique all the credit that she needs. A great attorney when it comes to domestic violence, family law, and child welfare law. Keith, we're going to go ahead and I'm going to share the screen right now, and we're just going to jump right into this. So the first thing I'm going to do is I'm going to share my screen, and we're going to let everybody see the help sheet that they're going to be following along with. The topic again, domestic violence, direct and cross-examination. Walk us through the green column.
Okay. Tom, to begin with, I set up a scenario to add a little flavor to this lecture.
Okay.
And the situation is there's a man named John and a woman named Mary. They have a dating relationship, and their relationship has deteriorated over the years. One night they go out to a dinner in a restaurant, and Mary has a slight drinking problem. She has this particular occasion, she had too much to drink, and when they walk out to the car, John doesn't want Mary to drive, so he digs in her purse to get the keys. Mary's offended. She begins to push and slap John, and in defense, John pushes her away, and when he pushes her away, she falls to the ground and breaks her wrist, and both parties file protective orders against each other.
And I like the way you didn't pick a scenario where it was a husband and wife and they got video cameras inside, and whatever horrible thing happens is all videotaped and it's just all clear cut, right? We want things where it's a gray area, right?
Yes, this is a more common situation. A lot of times when we go to court and trial, um, there's not a lot of witnesses, there's not video cameras, and it comes down to a swearing contest. And so I set up a situation where this would be the most common situation or a common scenario where there's very few witnesses and the situation gets pushed and nudged forward by each person a little step at a time. And it's really difficult to tell who's right and who's wrong.
And in Western cultures, we call that a he said, she said, which means we really don't know what anybody said, right?
Yes,
Because
that's what
we
we said.
because we weren't there, because if we were there, we wouldn't be lawyers, we would be
Yeah,
witnesses. We'd be witnesses.
that's
Okay,
right.
walk us through the green column.
Okay, so we're going into court. We're getting ready to try our case, and I'm looking to get a protective order with my client. And the first thing, obviously, every competent lawyer wants to do is get familiar with the law of their jurisdiction. They should know things about burden of proof. And I'm going to tell you, no matter what jurisdiction you're in, you not only probably have the burden of proof, but it's the burden of persuasion. Burden of persuasion you got to come across credible to the court. Um, so with keep in mind those two burdens, we begin by looking at the personal background of each of the parties. What we would look at is the nature of the relationship. Is it a close family relationship, say husband and wife, or is it a dating relationship? And so we really want to begin our case putting on a witnesses that can discuss the nature of the relationship or the background. So, for example, you would have your first witness on the stand. Can you tell me your full name and the relationship of the between you and the other party? You would want to ask background questions. How long have you known this other person? What things have you done together? Give the court a little bit of flavor and go into a little bit of history of maybe how many times you've spent the night, how many times you've held hands, or maybe you've been intimate or not intimate. But you really want to start to establish a good background, a good relationship, so the court has a foundation for finding that either a dating or a family relationship has taken
Understood.
place.
Absolutely.
Okay. Next thing, the next step is, well, first you're going to consider how many witnesses do you want to establish this dating relationship? I would guess most of the time you could establish the relationship with just the two primary parties. That often isn't an issue that presents problems during these court proceedings. But next thing, it's very important, is let's talk about the facts leading up to this particular event. And
Absolutely.
if we use the scenario between John and Mary, what we have is a dating relationship that has deteriorated over some period of time. So then what we can talk about is, let's talk about facts that has caused the deterioration of relationship. Maybe John's going to testify that, the last 7 times they've gone out, she's had too many drinks. And when she drinks, she routinely says things and does things that pose a danger to herself or begins a conflict between the two parties.
Or
So
or she says he's been to batterers class twice with two previous relationships, and here are his certificates and his convictions from two previous battering convictions, assault.
that's correct. And see, now the battle begins. It's a struggle right now. Whose version is going to be more believable? So, um, when you're getting your clients on the stand or whoever your witnesses are, you got to contemplate, how far back do you really want to go in setting up the events? It could be something short as a few hours, but it may be as long as of days or months. In this particular scenario, Mary's been a habitual drinker, and it's important to lay up a good foundation so the judge will believe that on this particular case that she was intoxicated. In doing those things, when we're talking about the events, it's, how many times did you get into any arguments with Mary about her drinking? What times of the day is she drinking? What type of drink does she drink? And how often? How many people have witnessed her drinking and becoming intoxicated? What things has she done while she's in a state of intoxication that would lead up to this scenario coming into effect? So those would be very important details for John's position when he's trying to build a case against Mary, because Mary went and attacked him when John pulled the keys out of her purse.
Now let's get to the incident details.
Okay, so when we talk about this incident details, this is a case where details are very important. Now, from John's perspective, the incident details begin when they went into the restaurant and discuss what she had to eat, how many drinks she ordered, the time period in between her ordering the 2 drinks or 3 drinks. What types of drinks were they? Were they, just beer, or were they hard liquor? Then discussed that maybe she began to slur her words and things that she did that demonstrated signs of intoxication. So what we're doing is we're building the case, we're discussing this incident like building blocks. You're laying a foundation. You're trying to tell this court a story about what happened. You do that with building blocks. So you've laid the foundation. Now we're at the restaurant. She's ordered these drinks. Your case is getting stronger. Now, as you're getting ready to leave, you can discuss, what was her demeanor as she was leaving the restaurant? What things did she say? What things did she do? Where the keys were in her purse. John would really want to identify and establish that Mary was intoxicated, so he felt he needed to go into her purse without permission. He may want to get into details why he just didn't ask permission, maybe because there was a history or foundation with, he knew that she wouldn't appreciate that. So John would begin to say, the first thing I did to protect us and to keep us safe was I took the keys away from her. And this is how she reacted. This is the first step that occurred that constituted an act of family violence, is what her very first reaction was. And it was, she went to grab the keys, pushed him, and slapped him in the face. So that's as we begin to set up the scenario. And it's important to set up this scenario as to something the court could latch onto and say, aha, this is the first factor that I'm going to consider. Because obviously Mary's going to set up a case of self-defense, or he started it. So you try to want to nip that in the bud from the very beginning. So John's going to say he went into the purse, that she reacted by pushing him, and that she kept attacking him, and he acted in self-defense, pushing her away. So those are more events of this significant events. Well, then she fell and she broke her wrist. So those would be the specific incidents that maybe occurred during this. And then what happens is let's take it a step further. We want to talk about some further details. Well, what happened after she fell? What was the next thing that happened? Did somebody call the police? Were there other people that witnesses who saw this incident? What did John do? What was his reaction after she fell to the ground? Did he try to help her? Did he point the finger? Was he yelling at her? Was she yelling back at him? Did an ambulance come? Did the police officers come? What were the injuries to her wrist? Did he show signs of remorse? Those are really important details that a judge would want to know. So when we're discussing these incidents.
And what I think about, you can see my screen, right?
Yes, I can, but
So
the print is
it,
small.
it sounds better in Latin, but you want that judge to think in his head. We say it in Latin, sanctus cacas. Holy shit, right? It needs to be when you have that thing that makes the judge stop and say, okay, that is, you need these sanctus cacas items of evidence or testimony, don't we?
Yes, we do.
Yeah. But say it in Latin to the judge. Say it in Latin to the judge. He'll appreciate it. Okay. Okay, let's go down the third column, which is yours as well. Questioning of supporting witnesses.
Okay, so when we're looking at supporting witnesses, one of the first things that you want to do is, depending upon the scenario, first thing is ask yourself how many witnesses you need to prove up this event. There are many times when, during the case of a trial that I have witnessed over my 25 years of experience, where an attorney puts 7 different witnesses on the stand, and inevitably, each witness does not share the exact same recollection of the other. And depending upon the burden of proof, you don't want to put on too many witnesses where your own witnesses will hurt yourself.
Consistency is often better than volume.
Exactly. So what we'll do is, depending upon the events, like this event at the restaurant, what you might want to do is have a couple witnesses from the restaurant, maybe the bartender. The bartender could possibly say, this is how many drinks I served her, this was her demeanor, or the waitress. So you want to look at witnesses, and then you want to look at the quality of the witness. Meaning, does the witness have a stake in this litigation? Is the witness a friend of either party, or is the witness neutral and would have no reason to lie? So establishing the credibility of a witness is very fundamental to the prosecution of one of these cases, or the defense. And then the next thing you'd look to with a witness is, was that witness able to support the testimony with her observations or his standpoint? Did he have a good view of what was going on? So, for example, if Mary had been drinking too much at the bar, you figured maybe the bartender or the waitress would be a good witness, but somebody else sitting 3 tables over that was already engaged in a conversation with a third party, that person, while maybe in the general proximity, their focus was not on John or Mary. So they may not be able to testify with a high degree of competency as to the events that took place because their focus was someplace else. So we're going to look at the credibility of witnesses. We want to look at um, one, do they have a motive? Two, were they able to testify competently from their standpoint in this transaction? Did they have a good view, or are their observations credible?
What's next?
All right. So when we want to, after we get done looking at the credibility of the witnesses, we'll put them on the stand. We'll solicit that particular testimony, and that's really where the art of lawyering comes into place. Is know your witnesses' testimony before they put on the stand. Be able, be able to question the veracity of their testimony before you put them on the stand, because if you don't, inevitably a witness may say something that you're not prepared for, and it could come back to bite you. So witness preparation is key, so you understand what's going to happen on the stand.
And obviously, that's going to, no matter what the local laws are, no matter what the predicates are to get in the evidence, that's a great general approach to any of those 80 countries with English-based legal systems.
So when we go to the next thing we're going to talk about is a response in the incident. So after the initial incident, and this would probably be the incident described as the altercation, the immediate altercation between John and Mary, where John goes in the purse, starts to pull out the keys. Mary begins to push him. He pushes her away and falls down. So what happens is we want to look at the response because inevitably there's going to come a time where one of the witnesses, their reaction to the event would be very significant in determining liability. For example, if John said, or first thing he said when she hit the ground is, "Gee, I'm sorry, I didn't mean that," that's significant to know. If Mary's the one that called the police, that's significant. If John's the one that called the police, that's significant. You want to look at how the parties responded because often um, the person that went too far may show signs of remorse, may show signs that, "Gee, I'm sorry." And these are goes to it relates to liability. It relates to who were the aggressor. Now, typically, the aggressor is going to, at some point, acknowledge a wrongdoing spontaneously at the scene of the incident. If John pushed her down, he didn't mean to. Look at his reaction. You can see if his reaction signs of remorse. Um, on the other hand, if Mary has been belligerent the entire time, when she falls down, if she continues to be belligerent, that's also important because you've got to humanize your client. If the court likes your client, if the court likes your witness, they're going to find a way to help your case. Whether a witness is likable or not likable or credible or uncredible, often these cases of family violence determine upon the credibility of a witness. So in determining credibility, one of the things you see is their response to the events.
And of course, that's really important depending on whether it's criminal law or personal injury law, the intent of the party that's now facing the brunt of a lawsuit or an accusation. If somebody did something to help somebody and the other person died and they're screaming, "Oh no, oh no, oh no, grab my hand," right? Intent and knowing what the burden of proof is so critical.
It is. Next thing we're looking at on my sheet, we talk about the physical evidence. So before going to court, you want to take a chance, you want to take the opportunity to look at all those things that you may want to introduce as evidence. It could be a video camera. It could be a text message. For example, so often does someone follow up an incident with a text message saying, "I'm sorry," or "I should have never have done that." Um, I had a case where a family violence where the dad was wrongfully accused. Mom had actually done it, and when she was in prison, she wrote letters from prison saying, I hope God can forgive me for what I've done." And these letters, the text messages, the videotapes, the tape recordings, um, maybe the medical records. These things are often physical evidence, tangible items that you would want to introduce to the court. Um, Pictures of the scene, those things you need to really consider how you're going to get these items into evidence, and they do have a significant impact. Oftentimes, people don't tell the truth on the stand, but when they submit a text message or an email on their own accord, where they don't think anybody's looking over their shoulder,
It comes
often
out a bit more unvarnished.
that's true, and often those emails are more credible, especially when they're being used against the person that wrote them, because no one forced that person to write the text message or the email. So when an email or a text message begins with, "I'm sorry, I really need to stop drinking. I'm going to check myself out into rehab." Um, that email adds so much credibility to the testimony because it's going to be hard for her to refute or dispute that she was intoxicated when shortly after this incident, she's sending some sort of text message or email about needing to check herself into a rehab. So the physical evidence is very important, and oftentimes that physical evidence will have more weight and credibility than the oral testimony between the parties.
We recorded part of this with her help sheet co-author Keith Gross. We are now able to catch up with Ronique in Washington, D.C. I think you're in Washington, D.C. right now, and we're still continuing on domestic violence, direct and cross-examination. So, Ronique, let's go ahead and focus on this column, the second column on the right. What is it that you want to tell us about this area as we work on down this column?
Hi, Tom. Thank you for having me. So, what I want to focus on cross-examination of witnesses is one thing to always remember is to ask leading questions. So, that's just pretty basic. You want to keep your witnesses to a point where they're answering yes or no, and they're not giving whole long answers and explanations for whatever their behaviors are. And so when you look at this column, it'll say, questions that explore whether a witness has made any prior reports or statements about the abuse. Well, the reason that that becomes important is because if you're going to impeach them, then you want to be able to show that they either have or have not made those kinds of statements in the past. And so when you ask, was this incident reported to the police? Because people will say, oh, well, I did. Or I was going to, there's all kinds of little wiggle spaces, and you don't really want to leave those spaces open. So you want to be very direct in that question on your cross-examination. So have you made a similar allegation in the past? Don't let them, well, waffle, yes or no. Is your testimony today different from what you told the police officer or other witnesses? You want to be able to impeach them with inconsistent statements. So you want to make sure that if that testimony is different. You want to make sure that you have that different testimony so that if they say no, you'll have that prior statement.
Or conversely, if it's your witness, you got to also prepare them for the cross-examination.
Absolutely. It is critical that you prepare for cross-examination and that you let your witness know how you want them to answer. So on a cross-examination, you don't want your witness giving a whole lot of information because they're just using that information against your witness. So yes, no, I don't know is always the first line of defense on cross-examination as you prepare your own witness.
Let's talk about the credibility of the witness.
So when you're looking at the credibility of the witness, you want to know, are they honest? How do they come across? Have they done anything previously that even kind of questions their trustworthiness? Even if whether or not they have had any interactions with law enforcement, have they been arrested? Have they been questioned? Have they been investigated? And you want to be able to put those things out there to suggest to the court that if they've previously had credibility issues, they may not be credible now.
And is this the first time you've been accused of domestic violence, even with somebody else, right? Regardless of which of the 80 countries with English-based legal systems, those are still the basic questions, right? That supersede the requirements of the jurisdiction, right? Getting down to credibility is so important. 'Cause, it's just, but same thing in life, right? When your
Mhm.
child says something to you, do they have the credibility to back up what they're saying? Answer's usually no, but we can hope for the best, right?
We can hope for the best, and
We can
sometimes it's
hope for the
no, and
best.
sometimes it's yes. But you definitely want to always look at that credibility question. And regardless of whether that has been with law enforcement, you might find that they've been, untruthful with their job in terms of your discovery, in that kind of case. So you don't want to let that go. And if they've been convicted of a crime, you obviously want to be able to bring that in and always be prepared to be able to bring that in properly. So for whatever your rules of evidence are in the jurisdiction in which you're practicing in, make certain that you are clear on how to get a prior conviction admitted because it is
Oh,
not always as simple as going and getting a certified government document. You have to prove up that that is the person that was convicted. And so sometimes you actually have to get a pen packet, and they're not easy to get in some jurisdictions. And so you want to be very careful about that. Do your homework. You don't want to lose the case because you couldn't get a prior conviction in front of the judge.
And can you explain the term pen packet for people in different countries who might not know that term?
Yes, I can. So what a pen packet is a penitentiary packet is where the name came from. They may not have been in the penitentiary. They may have only been in a county jail. But what it is their mugshot, their jail ID number, which is in our jurisdiction called a SPIN number. It is a copy of their fingerprints, and it is a copy of the judgment against them or the conviction. So that's what's in that packet.
Okay, next box you created for us was observation details.
Yes. So when you're doing cross-examination, you really want to find out how much did they observe and how credible, you're going right back to credibility, how credible is what they say that they've seen. So how far away were you when you claim to have seen the incident? People will say, oh, it was a fight and I saw it. But how far away were you? You don't know who did what to whom, how it was happening. So you want to be able to question that. How dark or well lit was the room? Were there any obstructions preventing you from clearly seeing what happened? We've all seen our, what is it, My Cousin Vinny in the US. And maybe in other countries you've seen this movie too. There is a hilarious scene where the attorney is cross-examining a witness and goes to the back of the room and says, how many fingers am I holding up? And as he walks up, she gets the number wrong and says, oh, maybe I need new glasses. Um, Nothing ever happens in real court as entertaining as that, but it really,
Oh, I don't know. I don't know.
but it goes to show
And it
how
didn't
important.
always go my way, but it still was entertaining.
Oh, absolutely. Getting those observation details is critical to your effective cross-examination.
Okay, memory reliability.
So memory reliability is the kind of thing where you're looking at how much does a person remember, how much of it is recollection, how much of it is something that was influenced by someone else. So you want to ask questions regarding the passage of time. How long was it? Potential trauma affecting the witness's memory, meaning are you remembering something that happened to you versus something that you think that you saw? The witness's memory, or whether others have influenced their recollection of events. That happens all the time where everybody's standing around and they're telling, oh, yeah, this happened, this happened, this happened. So is it really your memory or is it really you recollecting what someone else told you? And so it becomes really clear, it becomes really critical in your cross-examination to make sure that you are not relaying what has been told to you. And then you have personal knowledge. So when you're doing cross-examination, you absolutely want to hone in on what did they see? And I
Okay,
always try to
I love
say
that.
a
I love that
witness.
last question. Has
Mhm.
anyone else discussed the events with you? As if are you starting to absorb what they said
Right,
as opposed to absorbing the actual event itself?
right. Which is why I say, as a witness, you want to know what did you see? And you want to make that focus on
Is that
you.
is that how you say it? Is that how
Yes,
you say it in court? I think I can picture it. Okay,
yes.
let's go on to the fourth column now. Cross-examination of hostile witnesses.
So, first thing that you want to do is you want to establish witness bias. You want to establish that they're hostile. You want the judge to know they're hostile. If you're in front of a jury, you want the jury to know they're hostile. It's gonna come out pretty quickly, but you want to get it out of the gate real quick. You can ask the judge, "Can I please treat this person as a hostile witness, in case you are the one calling them, so that you can use leading questions and cross-examine them, not direct examine them." So when you do that, you want to identify the bias or motive that the witness may have that would impact the testimony or credibility. That's how you're establishing them as a hostile witness. And then when you bring that in, you want to know, do you have any personal or professional relationship with the opposing party? Have you discussed your testimony with anyone involved in this case? Are you do you have anything to gain by a verdict in this case, whatever that verdict may be? And so that's how you want to establish whether or not that witness has any bias that the court should look at, and whether or not that court should use that in their consideration of whether the domestic violence did or did not occur.
You know, sometimes when the judge interviews in family law cases in certain countries and they interview the child in chambers, you really spurred an idea. You know, sometimes you can suggest to the judge what questions to ask, right?
Mhm.
Judge, you might consider asking the children what they may gain or lose depending on which parent you pick.
Oh, absolutely. Because bribery of children is real.
Absolutely. Absolutely. Okay, next you have inconsistencies in the testimony.
Yes. So you always want to have your prior statements codified somewhere, either in depositions, in interrogatory responses, in documents provided in requests for productions, so that when you get to court, you can use that. Because you can say in your prior deposition, you stated X. However, today you said Y. Can you just explain this discrepancy? Did you review your notes before testifying? Do your notes reflect that in your previous statement you said X? So you always want to have those things codified, written down, at your disposal, and tab them. Make sure that you know where they are, because in trial, you might be in a position where you need to look really quickly and it's like, oh, I remember they said X, right? And it's like, oh, on such and such and such a day, didn't you say? That is, it gets them thrown off. It lets the judge know that you are prepared, but it also really highlights that somebody somewhere is not being truthful, and that's the purpose of your cross-examination, because that's the purpose of examinations for both sides, right? Is to get to the truth of the matter.
Challenging observation. Somebody makes an observation that's damaging to your client. How do you approach such witnesses?
So you want to question that witness's ability to accurately observe or recall the events in question, right? Visibility, distance, distractions. What are those things? How far away from you were you from the event? Like my previous example, were there any obstructions or distractions that could have impacted your observation? Same thing. You want to be able to challenge that they saw what they saw. If they say, "Oh, I saw him hit," or "I saw her hit," right? And you say, "Well, where was their hand placement? And what was between you and their hand?" Well, how could you see? Well, how many times did a hand fly? And you keep peppering them in that manner, they're going to get lost, right? And so that's a strategy, is to really challenge, did you really see what you said you saw?
Of course, you don't want witnesses testifying to things that could be damaging to your client if it's not even relevant.
Absolutely. So if you want to make sure, because they will bring up all kinds of things. So on cross-examination, your goal is to shut down all of that extraneous conversation. So the description of the facts, omit key elements of the events. Yeah, you want to find that out. Did you personally witness the key events in question? As I said before, did you see it? Witnesses see, right? So that's one of the ways why how you keep hearsay out. Don't, oh, on 2 years ago, I saw the defendant or respondent, whatever jurisdiction your jurisdiction uses, I saw them do blah, 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 blah. Okay, well, that doesn't have anything to do with why we're here today. So if it doesn't have anything to do with it, don't allow that to be discussed. And don't ask any open-ended questions where if you object to that, the judge can say, well, you opened the door.
Why did you do this? Blah,
Don't ask that
blah,
on
blah, blah.
cross-examination.
Why? Well, okay. You know, I think about the next one on credibility of witness. The one thing I like to do in trial, I'll say, look at the judge right now. Turn to your right, look at the judge, and tell the judge you're not lying about this. And sometimes you have them go, I'm not lying about this. You know, every lawyer's got that. I've never seen you in trial. I hear you're pretty darn good. I know you're one of the rare board certified attorneys in family law in our jurisdiction of Texas, the second largest state in the United States by population. But what are the things that you do when wanting to either, well, right now we're on hostile witnesses, so to attack the credibility of a witness?
So one of the things that I do, I will definitely ask about the relationship between the witness and the respondent or the defendant if I am the protagonist. Have you ever been convicted of a crime involving dishonesty, right? Because there's theft, right? There's fraud, there's all kinds of things that people think are just minor little things. Sometimes you can even ask about insurance problems, right? Because if you live in a jurisdiction where insurance is required and they got an insurance case, and they had to go get an SR-22, which is just some elevated insurance because you've driven without insurance before or you've been caught without insurance before. That's fraud. It's fraud on the drivers, it's fraud on the other citizens, it's fraud on the insurance company. And so that is a crime of dishonesty. And so you
And we
can't
and we call that a crime of
moral turpitude.
moral turpitude. It sounds so much worse, doesn't it?
It does, and I don't know if other jurisdictions use that terminology, but definitely want to say that it doesn't have to be the crime that you think is the big smoking gun, entertaining. Everybody is going to clutch their pearls and go, oh my. It doesn't have to be that. It could be something as simple as an insurance violation.
Okay, so we're finishing up on our help sheet, domestic violence, direct and cross-examination, the last column of this topic regarding hostile witnesses contradicting opposing claims.
All right, so you want to use your cross-examination to address points in that testimony that support the opposing party's claims and attempt to disprove or cast doubt on them, right? So you want to be in a position to question, did the domestic violence happen? All right. You mentioned X in your testimony, but does this contradict what the defendant stated? Right. So if you've got a separate witness, not the victim or not the respondent, but a third party witness, someone who says that they saw it, or maybe even, a medical provider, you want to be able to contradict what the victim said, right? So if the victim says, I came in and I had pain on my left side, but the nurse or the other professional says, I came in and they describe pain on their right side. That's a contradiction. And so you want to be able to explore and exploit those. Can you confirm this detail does not align with the evidence provided? You want to be able to put that in front of that witness, that nurse, or that other medical provider, and just say, hey, so you said that you examined the left side, but they in fact said that they examined the right. Contradiction.
Right. Okay, let's go ahead and show people your website in case people around the world wish to contact you. I've got your website ready right here to show the world. I believe your web address is bastinelaw.com. We were
It
here
is.
earlier with Keith Gross, one of the attorneys who did this topic with you and Keith put together this help sheet together. And when we recorded this earlier, we did give you props in case you were not able to make it, but we were glad that you were able to make it. And so Ronique, thanks. Oh, there's that professional picture I told you of yours that I absolutely love that picture. That is a great picture.
Thank you.
Okay, so
Thank you so
Ronique,
much. I appreciate
thank
it.
you so much. It's the second time when you've participated in a domestic violence CLE
Yeah.
with us, but this time with Toolkit.law for our global CLE event. So thank you very much.
Well, thank you. Thank you for inviting me.